Advanced Legal English, Advanced Legal Vocabulary for teachers and students as well. Today, our topic is contract law and enforceable contract. We'll talk about enforceable contract. We'll delve into an exciting topic with many various exercises with the best solutions and detailed explanations, and also voice with reading passages and writings with vocabulary to expand your vocabulary. So if you would like to stay in tune, to keep updated, and also wise to get more and more such kind of lessons, I advise you to subscribe my YouTube channel for free and valuable lessons. Also wise, you can easily download all the materials that I have free video lessons through my Telegram channel. I also advise you to join my Telegram channel for free and valuable materials and resources. First and foremost, let me read for you the reading passage regarding contract law and especially enforceability of contracts. What is that? The essential feature of a contractual relationship is that it's an exchange relationship which is voluntary and consensual. It can be created by oral or written agreement between two or even more parties. It contains at least one promise and is recognized in law as enforceable. The element of agreement distinguishes contractual obligations from many other kinds of legal duty that arise by operation of law from some act or even where there is no necessity for assent. By entering into an agreement, the parties bind themselves to each other for the common purpose of the contract, and therefore the essence of the contract is the relationship. To determine whether the parties actually agree to the contract and whether they agree to all the terms of the contract is not always easy, surely. In deciding whether a person actually agreed to a contract, the law usually looks objectively at the intent of the parties. Oral contracts may be enforceable in certain circumstances, whereas certain types of contracts must be recorded in writing and signed in order to be enforceable. The legal doctrine known as the statute of frauds was developed in English common law, but similar rules have been codified in other jurisdictions, including the United States. For contract formation, certain requirements are necessary to ensure valid enforceable contracts under common and civil law. However, in order to remove ambiguities caused by various domestic laws concerning contracts for the international sale of goods, the United Nations Convention on Contracts for the International Sale of Goods, CISG abbreviation, was adopted in 1980. Unless specifically excluded, it applies to contracts between companies located in various countries, and to date, over two-thirds of the world's countries have ratified this convention. While the CISG, International Sale of Goods, provides a uniformed tax of laws for international sale of goods, the UNIDROIT principles are a non-building attempt to reach a progressive harmonization of the general principles of contract law. So the aim of UNIDROIT is to establish a balanced set of rules designed for the use throughout the world, irrespective of the legal traditions and the economic and political conditions of the countries in which they are applied. So let's go to the vocabulary of contract law and legal English. So here we need to find synonyms with the appropriate words from the article and passage. First, very important, essential. Second, without outside pressure, voluntary. Third, agreed by both parties. Consensual force make it various from, distinguishes. 5, tie, bind. 6, the same for age, common. Similar, it means 7, decide, determine. 8, legally acceptable, enforceable. So that's our actually keywords here. It's our highlighted words. Enforceable, legally accepted. 9, officially accepted, ratified. 10, the same for everyone, uniformed. 11, outside and not concerning, that's irrespective. So that's your vocabulary to learn very easily, such as legal English. Let's go for the following exercises. Here we do have reading passage with gaps that we need to fill the gaps with the appropriate words or expressions or even prepositions. And our passage under the title is Buyer's Terms and Conditions and Unfair Contract Terms. So, subheading of this reading passage is the Unfair Contract Terms Act. The first paragraph is transactions between businesses are covered by. So covered by our actually covered by our phrasal verbs by the Unfair Contract Terms Act 1977. UCTA is abbreviation. In general, businesses are assumed to be free to enter into wherever contracts they agree between themselves. So you should make sure. So that's actually more cliche allocations. Make sure you're happy with the contracts you agree with other businesses. However, UCTA, Unfair Contract Terms Act, places a number of restrictions on the contract terms businesses can agree to. Specifically, it lays down rules for the ways in which vendor businesses can use exclusion clauses to limit liability in certain areas, such as excluding liability for death or injury is not permitted in any circumstances. That's our actually expressions, in any circumstances. Excluding liability for losses caused or even incurred by negligence is permitted only if it is reasonable. And excluding liability for defective or poor quality goods is also permitted only if it is reasonable as well. And the next subheading is the test of reasonableness. UCTA doesn't define precisely shortly what is meant. So what is meant is the past by reasonable, but courts will usually take into an account, such as the information available to both parties when the contract was drawn up. Contract draw up. Next, whether the contract was negotiated or is in a standard form. And next, whether the purchaser had the bargaining power to negotiate better terms. Businesses don't have the same protection as individual consumers. A consumer contract excluding liability for defective goods would or will, that's the same, be automatically invalid. But as a business purchaser, it's up to you to check in advance what terms and conditions you are agreeing to. At present, there are separate rules dealing with unfair consumer contracts, the unfair terms in consumer contracts regulations. Sole traders are regarded as businesses rather than consumers for any purchases they make in connection with their business activities. However, if the trade offers you credit terms up to £25,000, you receive the same protection as individuals under the Consumer Credit Act 1974 for this element of the contract. That's all for our lesson, and thanks for watching.